The International Criminal Court (ICC) will on April 10th and 11th formally commence trials against 4 Kenyans facing crimes against humanity charges at the Hague-based court. But just about 2 months to the 4 suspects' day in court, one of them, Deputy Prime Minister Uhuru Kenyatta, has through his lawyers made an application to return his case to the court's pre-trial chamber for a fresh assessment.
Thank you, Your Honor. My name's Uhuru Kenyatta.
Kenyatta, in the application filed by his attorneys, Stephen K. and Julian Higgins, argues that the prime witness, who linked him with the post-election violence charges, had recanted his evidence. The witness, only identified as witness number 4, withdrew his evidence and disclosed that he had been coerced and induced to implicate Kenyatta by persons he did not name. The witness had claimed in his evidence that he was part of the Mungiki delegation that met Kenyatta and his co-accused former head of civil service, Ambassador Francis Mudhaura, at State House, Nairobi, where retaliatory attacks against perceived ODM supporters in Naivasha and Nakuru were planned. A meeting the witness claimed was also attended by President Mwai Kibaki.
That I will perform my duties and exercise my powers as prosecutor of the International Criminal Court.
Kenyatta argues that since one of the prosecution's star witnesses had denounced his evidence, it would be a miscarriage of justice if he was to be tried, since the pre-trial chamber used the witness's account to confirm his charges. But Kenyatta's application may hit a dead end, according to international law scholar Dr Godfrey Musila.
Only the prosecutor can cause a return to the pre-trial chamber. And there are 2 circumstances that are contemplated. If the prosecutor amends the charges by adding new charges, or replaces the charges that were there before with more serious charges, there is a mandatory requirement for a new confirmation hearing.
ICC prosecutor Fatou Bensouda would also frustrate Kenyatta's application by proving to the court that the departure of witness number 4 would not injure her case against Kenyatta.
The question would be for determination whether in fact the withdrawal of witness number 4 is such that there is no other way that the prosecutor can create the link, the necessary link between Ambassador Mudhaura and Uhuru with the Mungiki. Because I think it's a fundamental link that needs to be created. So the question is, are there other ways in the evidence as it is now that that link can be created? If they exist, then the request by Uhuru is invalid. It's really not a very useful one.
Musila points out that Kenyatta's lawyers could also have raised the matter as a preliminary issue when the trial process kicks off on April 10th, since the trial chamber also had powers to hear and determine any outstanding matter from the pre-trial process.
Because in essence, if that link cannot be created, the case against Uhuru would collapse. So that is a question that has to be determined at the outset by the trial chamber.
And for witness number 4, who has recanted his evidence, claiming that he had been coerced by some unnamed forces, are there any legal repercussions?
If in fact the claim that they were coerced can be verified, the Rome Statute provides for offenses against the administration of justice. And it says that anyone who interferes with a witness, attempts to corrupt a witness, would be guilty of an offense against admission of justice and will be tried at the ICC.
The 4 ICC suspects have been summoned to appear before the court on 14th of this month for a status conference. The suspects have the option of appearing before the trial chamber in person or through a video link. Kenyatta and Ruto have not yet confirmed the option they will take. During the status conference, the prosecution and the defense will be expected to agree on disclosure of the identity of witnesses and their evidence before the trials kick off in April. Francis Gachuri, Citizen Live at 9.